SJC-10344, Biogen, IDEC versus the Commonwealth.
Mr. Guberman, good morning.
Good morning, Madam Chief Justice, and may it please the Court. Assistant Attorney General David A. Guberman for the Commonwealth. The Treasurer's adjudicatory administrative decision that Biogen is holding hundreds of thousands of dollars of intangible personal property that is owned by the payees of checks that have gone unclaimed for more than 3 years is right as a matter of law and supported by substantial evidence. To show this, I want to discuss 3 points. First, legislative intent. Second, the unambiguous meaning of the technical statutory terms credit balances and checks. And third, evidence from Biogen itself that as a result of Biogen's own actions, no credit balances were outstanding at the time the property was deemed abandoned. First, as this Court held in the John Hancock case, contractual obligations are intangible personal property subject to Section 5 of the statute. The legislature's purpose in amending Section 5 was, as the legislature said, to exempt certain outstanding credit balances, because when a buyer has ongoing business dealings with its vendors, the amounts at issue or owed may vary up and down over time, resulting in credit balances that vary up and down over time. Also, as the Treasurer explained in his decision, when credit balances are resolved, sometimes due to less than diligent bookkeeping, is the phrase the Treasurer used, they may remain on the company's books of account. The intent of the legislature was to protect businesses in this precise situation. In this connection, I would note that amici and Biogen sometimes like to refer to what the legislature said was an exemption for certain outstanding credit balances as a blanket business-to-business exemption. That language is not in the statute. The Associated Industries of Massachusetts, one of the amici in this case, proposed such legislation. The legislature did not enact it. It instead enacted the outstanding credit balances language. Indeed, if one compares amici's brief at page 7, in which they say the exemption was intended to remove all ordinary commercial debts from the scope of the Act, with the testimony that Ames Vice President gave in 2001 in connection with hearings on the 2001 regulations, and that's at page 422, I believe, of the appendix. The testimony there, I'm sorry, it's not page 422. Yeah, I'm looking at the wrong page, just a moment. It is at page 422, and it's beginning at line 8, and the testimony was that the legislature, she says, let me touch briefly on the 4 changes that Chapter 198 of the Acts of 2000 made to the abandoned property statute. And speaking of this exemption, she said, an exemption for credit balances resulting from vendor-to-vendor transactions occurring in the ordinary course of business. And except for the fact that she omitted the word outstanding, which the legislature included, we would agree with that explanation of what the legislature was trying to do.
I have a question for you.
Yes, Your Honor.
The judge below, among other things, looked at an affidavit from a Mr. Mitro.
Ms. Mitro, yes.
Ms. Mitro. And that seems to at least confirm that at some point in time, Treasurer Cahill's office felt that although they agreed with Treasurer O'Brien's interpretation of credit balance exceptions, we certainly can offer a different interpretation at present. If the decision is to say that it does not extend, this is another area where we would have to amend the existing regs to lend clarity to the issue.
Well,
Would you explain that, speak to that?
Yes. First, I'll speak to it, and then, if I may, I'd like to explain why that's not properly part of this case. What was going on in those emails is that the Associate General Counsel for the Abandoned Property Division, who is now the Assistant Secretary in charge of it, was saying to the then Assistant Secretary that with respect to the exemption, the prior treasurer had done two things. One, by regulation, she had said that it would apply retroactively, even though I may say there's nothing in the statute that indicates that it's to apply retroactively. And second, by an internal practice, she extended it to unclaimed checks. And he says if one reads all of the emails together, and not just the part in that email that you read, but I believe there's a paragraph before that, I think what emerges from that is that Mr. McAnespie was saying regulation can't change the law if it's wrong, but it's something that we could amend. And the practice is not binding on it, but to lend clarity. He doesn't say to change the result, but to lend clarity, because it's confusing if someone looks at a regulation and sees one thing and then the practice that's actually being followed is at variance with the regulation. We could amend the regulation. That's with regard to the substance. With regard to whether it's properly before you, this is a Chapter 38 case. It should be decided, and it should have been decided by the Superior Court on the administrative record. Indeed, Biogen filed a motion for leave to enlarge the administrative record, which we opposed, and it was denied. Then, in connection with their motion for judgment on the pleadings, they filed this affidavit with a lot of materials in it, some commentary, which I think is fair game. You take it for whatever it's worth. But some attempted to establish facts that were not in the administrative record. And in our opposition to their motion for judgment on the pleadings, we said no. This is a Chapter 38 case confined to the administrative record. In all events, if the Superior Court thought that there was something in this extra record material that was worthy of consideration, what the court ought to have done under Chapter 38, Section 14, is to remand the case back to the treasurer, not decide the case on the basis of extra record information that Biogen had put in, which, in addition to violating Chapter 30A and the sense of what is judicial review of administrative action, also deprives the treasurer of any opportunity to respond to the factual claims that Biogen is making. So that's my answer to that question. But I'd like to come back, if I may, to explain why the considerations that animated the legislature in adopting the exemption do not apply when the buyer issues a check to pay off an accounts payable. Issuing the check creates a fixed obligation, one that is independent from whatever appears on the company's books of account. The amount shown on the check, unlike a credit balance, is not subject to fluctuation over time. Rather, under the Uniform Commercial Code, a check is an unconditional order to pay a fixed amount of money. And you explained in the John Hancock case that in that case it was John Hancock's obligations, here they are Biogen's, that these obligations are a debt owned by the payee of the check. So Biogen owes a debt to its payees. Those debts are not credit balances. The checks signify an independent obligation, and therefore the exemption for certain outstanding credit balances has no application.
Well, if that's true, though, the check was in the possession of the payor, Biogen, right?
It's not entirely clear, I think, in the record
Well,
where all the checks were.
Well, how do we know the payee has the check?
We don't know that the payee has the check either.
Don't you have to show that the payee has the check in order to to prove your case that it was abandoned?
No, Your Honor, that's answered by John Hancock. In John Hancock, this court was dealing with unclaimed checks. If the payee had the check, or if it were, and knew about it, the payee could have come forward. When we're dealing,
But how do you know the payee knew about it?
we don't know that the payee knew about it.
Don't you have to prove that to show that it's
No,
abandoned?
no, because a check is an unconditional order to pay a fixed amount. Once they've issued the check,
But the person that's abandoned it, the check,
Yes.
which is the evidence
Yeah.
of the right to
Yeah.
collect on it, we don't even know if they know it exists. So
That's-
how can you say that they abandoned it?
because the statute says that if it's unclaimed for 3 years, the dormancy period, it is presumed to be abandoned. The treasurer, at least once a year, maybe more than once a year, has been taking out advertisements, full-page advertisements, multi-page advertisements in the papers. I think it's now posted on the website, listing where it knows the identities of abandoned property, particularly bank accounts as an example. And presumably the reason that the treasurer is advertising is because these are owners of intangible personal property who don't know that they own it. And the treasurer is trying to tell them that they do own it. That it's not a question of whether the true owner knows that the property exists. The purpose of the abandoned property statute, or actually their purpose is, as Governor Dever said in his message to the legislature proposing the bill and what became the statute, one, certainly, to reunite the true owner of the property with the property. Second, for the period of time that that reunion is not able to be accomplished, to make sure that the benefit of that windfall doesn't accrue to the holder of the property, who doesn't own it but just happens to have it in its possession, but accrues to the benefit of the public and the Commonwealth. And you said the same thing again in the John Hancock case.
Is it your position that, A, if Biogen had not written the checks, this would simply remain as a credit balance and wouldn't be subject to the abandoned property law?
If it were still showing on its books as a credit balance, yes, it would be covered by the exemption.
If they wrote the check, it was unclaimed, and then they put it back on their books as a credit balance, I don't know, maybe there's an accounting way to do that when the check is unclaimed for a period of time, maybe not. Same thing, same result?
Possibly. It's not this case. The reason I say possibly is because if the check actually is in the hands of the payee, or it comes into the possession of the payee, whatever Biogen has done can't erase the fact that that debt is owed.
All right, and I'm not an accountant, but so when it gets reduced to a check, it's off the credit balance account, it's into some other account.
Well, I can walk you through the process if you'd like. This is from the...
I don't want to bore everyone to tears, trust me on that.
No, so, go ahead.
Okay, this is all in the record from Biogen itself. Biogen's written summary of its contentions at page 160 of the appendix, and Kelmar's examination report at page 23 of the appendix. When Biogen buys, let's say Biogen buys $100 worth of widgets, and it buys the widgets on credit. So what it does is to debit or increase its expense account by $100, and it credits accounts payable by $100. And at that point, a credit balance exists of $100 in favor of the vendor, and you can see it on the company's books. When Biogen writes a check to pay off the account payable, it debits or decreases accounts payable. It takes the credit balance off of the books, and it credits or reduces the cash account because it's taken $100 and it's written a check, and that now belongs to the payee of the check. When, and this goes back to your explanation or discussion of what happened here, when Biogen, after a year goes by without the check having been cashed, decides to write off the check, it debits cash, which increases the cash by that $100, and it credits the expense account, which reduces it by $100. What it does not do is to recreate a credit balance on its books, and that's why there's no outstanding credit balance to cover it when the property is deemed presumed to be abandoned. Very briefly,
But essentially, then, isn't that foolish accounting? Because under your theory, that money belongs to the state. The unclaimed checks, that amount has to be paid to the Commonwealth.
well, after 1 year it doesn't. The dormancy period
Okay,
is...
but I mean, after 3 years.
And after 3 years, the argument can be made, and as I say, that's not presented in this case, but the argument can be made that by restoring it as a credit balance, Biogen, while acknowledging that the money is owed to the vendor, is putting it back in play in the process of the ongoing back-and-forth dealings
With the
between
vendor.
the buyer and
So
its
then
vendors.
you wouldn't get it. It wouldn't be abandoned anymore. It would
So-
be in play between the two.
It could be argued that way. There's an argument that could be made the other way. As I said, that question really isn't before you. What's clear is that Biogen didn't do that in this case. If I may just by sort of head points, just say a few words about the other point I wanted to make.
Mr.
And
Guberman,
that is,
Mr. Guberman, your time is up, and we will, I can assure you, lead the briefs.
all right. Thank you
Thank
very
you.
much, Your Honors.
Mr. Halston?
May it please the Court, my name is Daniel Halston here on behalf of Biogen to argue that the judgment should be affirmed because, first, the second paragraph of Section 5 of General Law 200A is ambiguous, and it is appropriate to consider and defer to the interpretation of the exemption reflected in Treasurer O'Brien's contemporaneous regulations, and as that interpretation was acknowledged in Treasurer Cahill's staff emails, and second, that Treasurer Cahill may not apply a new interpretation of the statute as reflected in the decision below retroactively and impose new duties and obligations on Biogen and the business community.
So what's so ambiguous about an outstanding credit balance? Isn't that a pretty fixed term?
It is not, Your Honor. The term itself is not defined anywhere in Chapter 200A or in Section 5.
Certainly in the industry, in the accounting industry, it's defined.
Not so clearly in terms of what was applied in Chapter 200A, Your Honor. In terms of the heart of ambiguity, what we are really suggesting to the Court is that contrary to the Treasurer's argument in his brief, it's not ambiguous because the parties disagree over the meaning. It's ambiguous because you have two reasonably well-informed persons, namely the two treasurers who are responsible to administer and enforce this program, coming out with starkly different interpretations as to what this credit balance means.
Well, I'm trying to figure out, reading the statute, what's ambiguous about it. And maybe that's because I don't know very much. But it seems to me that a credit balance is a credit balance, and it's pretty clear that what we have here are not credit balances.
Well, what we have here is a Section 5 that refers to credit balances shall be exempt from intangible property that are otherwise deemed abandoned under that Section 5. In terms of what credit balances mean, the Treasurer would refer you to Section 1 and the definitions of credit balances. But you turn to that Section 1, there is no definition of credit balances. What you have are groupings, different types of intangible property set up in various subgroupings, Your Honor. And as we point out in the brief, those groupings are not hermetically sealed from one another, such that, for example, as we point out in our brief, you have money that is used in various ways in those groupings. So you have it in subsection small Roman numeral 1, but you also have it, if you think about money as an asset that can be readily converted to cash, in effect describing the elements that are in subsections 4 in terms of distributions and dividends and interests. Similarly, if you look at subsection small Roman numeral 2, where credit balances is listed, what you're hearing from the Treasury as well, because credit balances is listed there, but checks is listed in another section, that somehow those terms are entirely distinct from one another. But look at that small Roman numeral 2. Right after credit balances, you see customer overpayments. The Treasurer here, both in his regulations and in the decision below, concedes that customer overpayments are an example of credit balances. If those terms, if each term was intended to be entirely distinct from one another, you wouldn't have customer overpayments separate from credit balances. And you can't look at that subgrouping and say, well, they're all examples of credit balances, because you get to the end and you've got unused airline tickets and mineral proceeds, and no one would suggest that those are examples of credit balances.
I mean, I'm not persuaded. I'm persuaded by you in that argument, but I still don't. If the auditor comes to your place and says, all right, let me see the what kind of credit balances do you have with your, commercial customers, vendors that are outstanding, these uncashed checks, which have now been taken into income, clearly don't qualify as that, do they?
Well, let's be careful about when we say taken into income. Certainly they have been now, Mr. Guggen's recitation was accurate in that effect that the cash balance then gets increased. But we're not talking about any new monies that are coming into Biogen. We're not talking about any windfall from any individuals. These are business-to-business relationships. And what Treasurer O'Brien, in the regulations and in her educational outreach effort, was intending to do was further the purpose of this statute. You go back to the cause of the enactment, the remedy that was to be mischieved by this, or the mischief that was to be remedied by this statute, and you look at the various statements of Treasurer O'Brien that are in the record. What you had at that time, back in 1999, was Treasurer O'Brien coming in because you had abusive audits in the prior Treasurer's administration, and you had the business community very upset about what had been happening. Treasurer O'Brien stepped in and decided she was going to lend clarity to this statute. And what did she do? She organized a task force of public sector and private sector representatives for 15 months.
Are you saying that what Treasurer Cahill came up with, forget this case, but just is wrong as a matter of law?
No, I'm not saying that, Your Honor. If Treasurer Cahill decided that this statute, as we contend, is ambiguous, as the current treasurer obligated to enforce this statute, he could come to a conclusion that that ambiguity could be cleared up by a regulation that says this is what a credit balance shall be.
Just don't do it retroactively.
Don't do it retroactively, Your Honor.
Okay.
Do it prospectively. And that is really the point. And that's really what I think this Court's decision in Baybank said. In somewhat analogous circumstances, albeit it was a tax situation as compared to the abandoned property, the Court said when the Commissioner of Revenue decided to change how certain bond premiums would be included in the basis for purposes of excise taxes, changed its interpretation. And in that case, you didn't even have a prior regulation like you have here that the business community could rely on. You had instruction sheets and policy statements. And notwithstanding that, the Court said you can't do it retroactively. There was no statute that was driving this change. You just decided to change the courses, the rules of an audit procedure in effect here midstream. Coming back, though, to the ambiguity and what Treasurer O'Brien was doing back in that 1999-2000 timeframe, she assembles this task force. She proposes the legislation. The legislation is made effective in November of 2000. What does the legislature do as part of that statute? Under Chapter 198, Section 4, it legislatively directs Treasurer O'Brien to go out and educate the business community on their obligations under that statute. And it obligates her under Section 5 of Chapter 198 to come back and report back to the legislature after her efforts over that ensuing year. What does she do in that time frame? She passes the first ever set of regulations under the abandoned property statute. And it's those regulations, because that's where we see the real difference. I mean, she says under those regulations, credit balances are not limited, in effect, Justice Cordy, to limited accounting principles.
To what everyone else in the world would think of an outstanding credit balance.
Instead, she says that what they apply is to any customer overpayments.
Anything ever owed ever.
Well, any other value potentially doing and owing between businesses. And why? Why would she implement a regulation of that sort? You go back to what was the cause of the enactment. Why was this passed? What we had was an overhaul of the abandoned property statute that she spearheaded back in that 99-2000 timeframe. The exemption was intended to eliminate burdens on businesses, and as the Superior Court noted, it was common for businesses to write off uncashed checks representing incomplete transactions between businesses. A member of the task force from AIM, who submitted a amicus brief in support of Biogen in this case, is quoted as saying, large businesses would have tens of thousands of these vendor checks on their books. And they could represent all sorts of sums. They could be coming down to very small. Just as an aside here, we have an issue here about these emails. What actually happened below was we wanted to get in. We did not represent Biogen at the administrative level. We wanted to get in before Judge Van Gestel documents that would show what these checks were. What were the underlying credit memos that Biogen would have to put together? What type of burden would it be on Biogen to handle $10, $20, $100 checks?
But what do you do with the record question, though?
Well, so that's what we moved to amend the record to get those documents in. At the same time, we served our briefs under 9A that included these emails and included press articles, for example, that quote from Treasurer O'Brien. We got those emails from the Treasurer because there was a dispute between the parties at the outset whether this was a Chapter 30A case or not. We agreed to disagree, but then ultimately reached agreement that we could refer to documents that bore on regulatory history. And those emails bear both on what was the Treasurer O'Brien's interpretation back in the 2000-2001 timeframe, because it makes clear it covers uncashed vendor checks. But it also bears on the regulatory history for the 2004 regulations that this Treasurer wants to apply retroactively. They knew they had a problem going back to February of 2003 with respect to the interpretation of this statute and what the business community had been told, how this statute and how these regulations were being applied. They did nothing. What did they do? They actually did do something. They audited Biogen starting in September of 2003, but only sought to amend these regulations during the course of that audit in February 2004.
Mr. Halston, I understand Mr. Goodman said this is a 30A. Where do we find in the record this agreement of yours that you can quote,
It's actually, we refer to it in our reply brief in the record below. It's not actually part of the administrative record, but it's obviously available to the court. And beyond the fact about the agreement, Your Honor, the parties' agreement is consistent with the law that provides that courts may consider documents outside the administrative record that bear on an agency's interpretation of a statute or regulation, or to discover an agency's contemporaneous construction of a term, or to see if an agency is acting consistently.
Now, the record reflect any reliance by Biogen on this understanding?
There's nothing specific to that in the record, Your Honor, although Judge Van Gestel did note that the community as a whole would have been entitled to rely on this interpretation as reflected by the emails and what was being communicated to the business community.
But how can Biogen be said to rely upon emails it never saw?
Well, remember, we have a treasurer who's legislatively directed to go out and go forth and educate the business community about how this new regulation, this new overhauled abandoned property statute was going to be applied. I think in that context it's very different, Your Honor. We are in a circumstance where the legislature has told Treasurer O'Brien to go out and explain what these regulations mean, and she does it.
Do you even need those emails to decide this case? If in fact the two regulations are different, if Treasurer O'Brien's regulation is different than Treasurer Cahill's, and what's being sought here is by the state is a retroactive application of Cahill's regulation. Can't this case be decided just on the face of it?
It could. I mean, I think, Your Honor, that the ambiguity that is present here, one could interpret the credit balance based on, and I think it is appropriate to defer to Treasurer O'Brien, even independent of the emails, because she was the contemporaneous regulator, who was interpreting the legislature's intent. And that you can't get a starker ambiguity, a case of ambiguity, where you've got the two regulators charged with the statute coming out 180 degrees from one another.
But what about her regulation back in 2001 would suggest that an accounts payable check would be deemed a credit balance?
The language, Your Honor, two things. First, when she enumerates the types of items that would fall within a credit balance, she says, she gave a liberal reading. She said it includes but is not limited to, and then she gave some examples. And then she said, or any other value potentially due and owing a commercial customer, either current or past. It's that language that one could then rely on. And why, just coming back, why would she interpret it broadly like that? Credit balances and it can arise in all hosts of circumstances. It could be a bookkeeping error. It could be the goods and services were never delivered. It could be an offset between the businesses. Businesses are not typically in the business of abandoning property. Businesses can protect themselves. Again, this is not an exemption that is in any way a windfall from any individuals. What you have in the press articles that review what Treasurer O'Brien was looking to do back in the 1999-2000 timeframe are references to the fact that businesses had a whole host of these transactions. They were clogging up their books. By doing what we've done here is you've reduced a burden on businesses going forward. And businesses have accountants. They have bookkeepers. They have monitoring systems to determine whether an account, in fact, is due and has not been paid. They're able to protect themselves. What we have here, just coming back to what Justice Cordy said, if you step back and think about it, what Treasurer is really saying is you have to create a line item and leave this thing open in perpetuity to get the benefit of the credit balance. Once you've reduced it to a check, you kind of have to wait. Nothing happens. No one's coming after it. You write off the check, but then you have to reinstate the balance on the book. And quite frankly, that makes no sense. It's just adding another administrative burden on the business community. And
Thank you, Mr. Holster.
for all these reasons, we request that the judgment be affirmed. Thank you.
I'm off this one.